Welcome, welcome, everybody. Thanks for joining us for another episode of Wigs for Wigs. I'm Joe Cook, joined once again by Bill Venezia, and today we're going to be joined by other special guests in order to discuss some of the legal issues in more detail that we have discussed on previous episodes, especially those facing Donald Trump, but we may dive into a couple other just basic legal questions because we've talked about some things as legal novices. So we have some actual experts who can fill us in on real details and real laws joining us on the show today. So I'm going to turn it over to Bill just for a moment to introduce our guests, and then we'll dive in with the discussion.
Well, while we're waiting for Brian Neary, we're joined by the former Hudson County prosecutor, former judge in New Jersey, the Honorable Edward DeFazio. And Ed has a wealth of knowledge from a prosecutorial standpoint, but also from a judicial standpoint. So what we want to discuss are the legal implications for the former president. Currently, there are 19 litigations that confront him. I went online to check. A lot of them were civil litigations with regard stemming to the Capitol Police and the different suits that they have against him for the January 6th riots, incitement of. But we're going to focus on 5 of the most important ones. One, of course, is the Manhattan District Attorney's indictment of former President Trump on 38 counts, criminal counts. We also have the civil trial going on by E. Jean Carroll against Donald Trump for rape and also for slander. That's civil and that's not criminal. And we have a pending case to be brought by the New York State Attorney General Letitia James against Trump and his children on behalf of the principals of the Trump Organization for fraudulent business practices. You know what? I'm going to start there before we
dive in. The question, just Judge DeFazio, thank you for joining us today. I just wanted to say that.
Thank you.
Before we go into the 2 criminal investigations, in the one in Georgia, the state one, and Jack Smith on a federal level, the question I have to ask with regard to the one by Letitia James, Ed, is that a criminal proceeding or is that a civil proceeding on a corporation?
That's a civil case being brought by the New York Attorney General.
Okay.
Now, if my understanding is correct, there were some kind of, was it civil charges that already the Trump Organization was found guilty of and forced to pay restitution? Was that a criminal charge against the organization, but not against specific individuals?
That was a separate criminal case against the Trump Organization and the accountant for the Trump Organization,
Weisselberg person. Okay.
Correct. That was a criminal case which resulted in a conviction, separate and apart from this civil case that's been brought by the Attorney General.
Okay. That case against Weisselberg and the Trump Organization, who brought that case? Was that the feds?
That case, I believe, was brought.
Letitia James.
Was that the Attorney General's office as well?
I think it was so. The Attorney General's office. Yes.
Let me just ask this on a basic legal question for our listeners. Just in general, we're talking about Donald Trump specifically, but facing both criminal charges and also civil cases. Can you just talk a little bit about the legal distinction between things like burden of proof and things like that in a civil case versus in a criminal case?
Well, in a criminal case, it must be proved beyond a reasonable doubt. In a civil case, the case can be proved by a preponderance of the evidence, which is a much less rigorous standard under the law. In essence, is it more likely than not that what is alleged took place?
Interesting.
So,
That's what I thought, but I wanted to clarify that for our listeners who,
so
we have listeners of different ages, students and things.
the
So,
current
Mhm.
civil litigation going on regarding E.G. and Carroll and Trump, the consequences for that, if found guilty, would be the jury or the judge decide on a monetary value of what has
Yes,
to.
the jury would decide on monetary damages.
I see. Okay. So it isn't a, with all of these swirling litigations, I think there's gonna be a lot of wealthy lawyers if they get paid. I mean, this is,
Well,
if they get paid is a key part.
as,
Uh,
as we know, former President Trump has a long history of stiffing his vendors.
Yeah. Well, he said that just makes him a smart businessman in the 2016 debates.
I think,
I
think-
disagree on that
I think
interpretation.
most attorneys are too smart not to get the money up front, Just, let's go back to the issue with the Manhattan District Attorney and Alvin Bragg. It's interesting, to a layman anyway, that the charges were not specified. There were 38 charges, and is that common in cases like this?
Well, in New Jersey, and I believe the same holds true for New York, the indictment does not have to go into the particulars of a case. It's only to put the defendant on notice of what the charges are. There are various vehicles that the defense would use to try to ascertain the details of the allegations. But that's not unusual. That is pro forma, let us say.
Okay, is that somewhat gamesmanship by the prosecution? Not to show their cards, don't they have to?
Not really, because the defense is going to be provided with extensive discovery in the criminal case, and discovery means the various reports and statements that have been developed through the course of the investigation. So it's really not gamesmanship. That's just the way these indictments are crafted, as opposed to in the federal system, where the indictments are much more detailed about the allegations.
Okay. I just want to shift to Atlanta, because this has been
Just before we shift to
Sure.
Atlanta, so with the New York case, a basic federalism question here. In the Michael Cohen conviction a few years ago, Donald Trump was essentially an unnamed co-conspirator in that conviction. Alvin Bragg cannot use that in his case to say that is the felony that Donald Trump was doing in connection with this misdemeanor that I'm charging him with. Can he? Because that was a federal charge versus he's bringing state charges. So he can't just say like Donald Trump would have been part of that conspiracy with Michael Cohen, therefore that is the felony that is in connection with this financial crime that I'm charging him with.
Well, of course, they're separate. They're separate and distinct cases. But I just want to pick up on something that you said, Joe. These charges brought by the Manhattan DA's office, they're not misdemeanor charges. They're criminal charges. They're felony charges. And I think there's some confusion generally about that. So I just think we should be clear that this prosecution in Manhattan is for criminal conduct, not just a misdemeanor.
Ed, is the law concurrent with regard to federal law and the law in New York and specifically Manhattan that basically can look into campaign finance? Are there laws that govern both, because I think what Trump's attorney that we just
Michael
referenced,
Cohen.
Michael Cohen was convicted of, I think it was wire fraud in terms of illegal campaign contributions and fraud, basically.
He also
Uh,
pled guilty to lying to Congress. but
He
that was-
pled guilty to lying to Congress, so there's a little bit of a distinction there. I'm unsure of to base a case on campaign finance law by a local district attorney. Is that possible under what you know of New York law?
I don't know. I don't know the answer to that, Bill. I don't know if there's separate campaign finance laws in the state of New York. But I'm just not sure.
I
Well,
guess,
I would assume that a prosecutor could say that rather than this catch and kill scheme and everything being in the furtherance of winning the election generally in the United States, it was to defraud the people of New York and deprive them of that information, even though he lost New York.
right.
Nonetheless, the criminal activity is still keeping that information from the people of New York by using this illegal campaign maneuver, which is what Alvin Bragg is alleging.
Well, it's interesting because there's a parallel to this, I believe, in both Atlanta and Jack Smith's federal, the special prosecutor for the federal charges that may relate to the Mar-a-Lago documents and also the January 6th riots. Can RICO statutes be used to basically say that there was a conspiracy to defraud the American public or the citizens of, say, Georgia, in terms of what Fannie Willis is trying to do? Do RICO statutes cover this stuff?
That would be extremely innovative, I must say. And I don't know if that's legally plausible, quite frankly. Just to go back, well, let's discuss all these cases, because although people may think there's a certain appeal, let us say, to these prosecutions of former President Trump, all of these prosecutions come with some difficult legal issues for the prosecutor, whoever it may be. Alvin Bragg's prosecution in Manhattan, and we really shouldn't get drawn into this, and I find myself doing it. It's not correct. We shouldn't be saying it's Alvin Bragg's prosecution. That's really not the way to describe it. But there's some very serious legal issues that are going to be litigated in that case. And the January 6th case that's being looked at by the special prosecutor, there are constitutional issues there concerning freedom of speech and Trump exercising his right of freedom of speech.
Right.
And the case and the voter fraud, using that term loosely, in Georgia, there are issues there. There are issues there concerning what the nuance of what was said by Trump
Hmm.
Honestly, the simplest case of all of them is the document case. If you accept the premise that former President Trump was obstructing, it's not just that the documents wound up there, because the documents wound up in Joe Biden's garage too.
Right.
It's that,
Mike Pence's dining room.
yeah, it's that Trump obstructed by not turning the documents over when there was a specific request to do so, and there was this effort to conceal the fact that they were in fact, meaning the documents were there. But I'm just, as far as criminal cases, the civil cases, of course, it's a different situation altogether. The standard of proof, as we said earlier,
Right, that's why I wanted to ask that earlier, because, you know, there are some of the Capitol Police officers have brought civil suits individually against Donald Trump and others in relation to January 6th.
Members of Congress, you know, individually and groups of them. But, you know, just getting back to the federal prosecution, just a few hours ago, the Proud Boys were convicted of.
Yes, they were.
4 of the 5 of them were convicted of
Seditious conspiracy.
Yeah, which it's interesting. Now, all of, you know, the Oath Keepers, they
were also convicted.
How does this advance Jack Smith's case about January 6th as they go up the food chain regarding to the events of that day, when common people have been convicted, pled guilty, have been sentenced for their crimes in trying to, if not overthrow the government, to stop the processes of government. And obviously, the Oath Keepers and the Proud Boys played a prominent role as an army, so to speak, to do this. How does that impact as you move up the food chain to those people who've actually perpetrated this conspiracy at the top? Was it impact?
Well, let me ask you this, Bill. Let me turn it around a little bit. When you say up the food chain,
Right.
What do you mean by that? Do you mean President Trump?
I mean, he's the top of the pyramid, and all the people.
I'm
that
thinking even
assisted
somebody like
him.
Roger Stone, who
Well,
we know coordinated,
Roger Stone,
worked with the
Rudy-
Proud Boys.
Rudy Giuliani.
You know, Joe, you kind of read my mind about where I was going. You know, moving up the food chain to get to former President Trump is going to be a difficult hike, perhaps. You know, are these people, for instance, are the Proud Boys? Is Mr. Enrique Tarrio, if I'm not mistaken, is the leader?
Yep.
I mean, is he number one? Would he be willing to give information to the government? Would he be willing to testify? Is he in a position to testify truthfully about any sort of communication he had directly or indirectly with President Trump? Those are the links that you have to establish, and for a criminal case, you have to have those links established in a very strong manner. I don't know where it would go, but to follow up on what you said, Joe, does it lead you to somebody like Roger Stone? All right. And would Roger Stone be willing to cooperate with the government against Trump? The answer to that, I believe, would be no.
Yeah, we've seen that already.
No.
He convicted.
Right.
But
So
that's another technical question I have on that issue, which is Roger Stone was already convicted of a federal charge and then pardoned by President Trump. That does not preclude him from being charged with something new in relation to these events that happened on January 6th after his pardon? Does it like a pardon doesn't
No.
just like,
It's not
That's-
blanket.
right, that's what,
It's not absolute immunity, no.
No.
It's
what
not.
I assumed, but I just wanted to be sure
Well,
of that.
When you consider seditious conspiracy conviction, I know they're not going to get the book thrown at them, but there are the charges pending too. That's a 20-year sentence max. I know he's not going to get that. But when you're looking at jail time, the oath keepers, some of their jail time was in excess of 3, 4, 5 years.
Correct.
If you're looking at that type of, consequence,
For
yeah,
years
I
joining us.
I would think you would be more apt to basically, testify. Because he was one of the few people who testify in his defense for the, during the trial. Most of the other Proud Boys did not. So it's going to be interesting to see if he gets squeezed to testify for those that he collaborated with above him.
I think you're right, Bill. There's certainly leverage.
Yeah.
But the question is, does he have information that is truthful? Could it be corroborated? And, we don't know, like a lot of things, we have no idea. I don't, and I'll rely on you gentlemen to help me with this. I don't know if there was any information that indicated that Tarrio communicated directly or indirectly with President Trump. I don't think
Not that
I don't think
I
there
know
has
of.
been, right?
No.
That's why I figured maybe more of a Roger Stone, somebody that we do know has more of a connection with some of these groups.
Right. And I think you're right about that. But as we just discussed, you could establish that.
Because I believe
But
Roger
does it-
Stone was even using Proud Boys for personal security. For
I think
himself,
I don't mean to chuckle about that, but I believe you're right. And that in and of itself is a very distressing proposition. But
Ed, I don't want to interrupt you, but we want to welcome in the esteemed defense attorney, preeminent defense attorney in the state of New Jersey, Mr. Brian Neary. And Brian, we've been discussing.
Thank you for joining us.
Thank you for joining us, Brian.
On another call, but here I am. Can you see me?
hello,
Yes,
hello, Brian.
yes.
Eddie, buddy.
Well, what we've discussed is the many litigations that face the former president. There are some 19 litigations, most of which are civil, but we've actually just been focusing on the federal prosecution or investigations by the special prosecutor, Jack Smith, with regard to January 6th and the Mar-a-Lago documents case, which pose, some jeopardy, legal jeopardy there. And we were asking Ed about what would the implications be for that ruling that was just hand down about the Proud Boys today in terms of convicting 4 of the 5 of them on seditious conspiracy. And how does that impact the federal case?
And I overheard Eddie say that I think the direct connection between the Proud Boy leaders and Trump is tenuous at best. He's a smart guy. He puts layers between, it's not like he's going to meet them in a corridor and, talk. And there's always he has this deniability. He talks like a mob guy. The mob guy speaks, if we do this, as if that's some sort of a signal. So while politically the January 6th case is probably the most disturbing against Trump, legally, I don't think you're ever going to see a prosecution for him on the January 6th. Now, get to Mar-a-Lago and the documents. Sure, he's got documents. sure, he's got this argument that that he has the ultimate, a president has the ultimate ability to declassify, which is bogus. He also has, so it's there. You've got then the political ramification of, well, Biden had him, other presidents have him. Hillary had the listserv, that, that kind of, or that kind of stuff, which again goes into the political. What I don't think we know about Mar-a-Lago is, are there other communications which may lead to obstruction? The obstruction of justice is the one. Not that I have the documents, but I'm going to lie about why I have the documents, why I have the documents, what I'm going to do with the documents. I think the obstruction is the more dangerous portion of this form, because A, shows his intent. He knew he was doing wrong, and B, obstruction in and of itself is a separate crime.
I see.
Right.
Yeah.
And I think Jack Smith, the prosecutor, there was a story just today about subpoenaing either the security tapes from Mar-a-Lago or the executives at the Trump organization who managed the security tapes. I think it was a man named Calamari. I don't remember his first name, who's actually in charge of security at Mar-a-Lago. And that was just the story today, that he's trying to bring him in for an interview, to try to figure out what exactly happened with some of the security footage and all there.
Just to jump a little bit to Georgia, which is that an unusual situation where there's a grand jury impaneled to see if there's indictable offenses to present to yet another grand jury? It kind of seems like legal chasing your tail. I mean, to a certain degree. Is that unusual to have a special grand jury convened to hear evidence and then make a decision as to?
Right, because this was essentially a fact-finding grand jury, is how I've heard it described, not really a criminal chart. Or maybe just somebody explain a little bit more about how the grand jury system works, maybe for our listeners.
Eddie, you want to first? Because I have a thought about how that would work in New Jersey, but you want to, since Eddie was the prosecutor for a number of years. In history, by the way, we should say I was the law clerk in the Hudson County Prosecutor's Office in 1974-75. As I was elevated to assistant prosecutor, do you know who my successor was? Eddie DeFazio.
Was one Donald Venezia Esquire there at the time?
Eddie, Eddie, let's not answer any of those questions.
I'll answer. The answer is yes, and we'll stop there.
Okay. I only see Judge Venezia at family weddings or funerals, occasionally at dinner. So I keep my arms length.
Well, in New Jersey, the grand jury is made up of 23 people, and they determine whether there's probable cause to believe a crime was committed and that the defendant was the person, probable cause, who did it. It's not in any way evidence of guilt. It's only, in essence, the vehicle to bring the charges before the court, and it takes a majority of the grand jury to return an indictment, and it cannot in any way be equated to what happens as the prosecution continues through the system, because as we discussed earlier, in order to convict somebody of a crime, the jurors must be convinced beyond a reasonable doubt. Probable cause is a much lower standard of proof.
Looking at the whole grand jury situation, so the prosecutor introduces witnesses. The witnesses are asked questions. And are they obligated to answer those questions in a grand jury situation? can they plead the Fifth Amendment not to incriminate themselves?
Yes,
Okay,
they can invoke their Fifth Amendment rights.
And this is
Brian would
something
know,
through-
Brian would know much more about that, having all of the defense experience that he has, criminal defense experience. But
Hey,
This is,
Eddie, hey, Billy, let me in on my computer. I'm showing up here. I'm gonna get off my phone.
okay,
Just put me in the computer here, okay?
okay.
this is something I brought up in a previous episode that we recorded, which is, and I asked people to correct me if I was incorrect, which is offers of immunity then to people who are.
That's me, guys.
All right, so if you get off your phone, we got you on
Yep.
you. That's
Okay,
that's
so-
better. That's better, Brian.
And the question I had raised in a previous episode that we recorded was if a person, talking about people taking the Fifth Amendment, if a person is then offered immunity from prosecution, are they then compelled to testify with the offer of immunity? Or can they still refuse to answer questions? You're muted.
You got to unmute
Brian,
yourself,
you're muted.
Brian. You have to unmute
if,
yourself.
if immunity is granted, the person is required to testify truthfully.
So they can no longer refuse to answer questions if they're offered immunity.
Correct.
Let's take a step back. See, there's two kinds of immunity. It's called transactional immunity, which means you're cleared. You're never going to get charged with the offense, or testimonial immunity. Listen, if you testify, we can't use what you say against you, but if we gather evidence otherwise, we can prosecute you. Okay.
Oh, okay. I wasn't
Most,
aware of that.
most immunity is testimonial in this situation. Now, you could go in there and say, I refuse to testify. Good. You get hold in front of a judge. Judge says you're ordered to testify. You can still say, I'm not going to do it. You're now in contempt of court. See you in jail, and you remain in the jail during the period of, and you can purge it at any time. All right, I'll come out and testify. Or you remain in custody until such time as the grand jury or the body compelling you to testify is dissolved. You could sit there for months while the grand jury continues on. You ultimately have the key to the jailhouse by going and testifying. But yeah, you can refuse, but there's a consequence to it.
Consequence, right?
You know, speaking of consequences, what kind of latitude, what kind of leverage does a judge have with someone like Donald Trump, who out of court says X, Y, or Z on social media that, can basically incite or cause violence? I mean, I don't know if the judges are basically going to throw the former president in jail on contempt charges, but what can happen? What kind of sanctions can be taken?
Right, just from an example, I mean, while Donald Trump was undergoing his indictment in court in New York, Donald Trump Jr. was tweeting out pictures of the judge's daughter, which, I mean, there's clearly something sinister there. In why else would you be tweeting out pictures of the judge's daughter? So what can a judge do in response to something like that?
The judge in the civil case, E. Jean Carroll, admonished Tacopina to control his the person he was representing, and it seems that he has. Although, Brian, to piggyback on that question, what do you think as a defense attorney in terms of the tack that Tacopina took with E. Jean Carroll on the witness stand? Was that something that benefited or took away from his case?
Okay, so full disclosure, I know Tacopina well, okay? I've done cases with him. I've been on television. I know Tacopina real well. There are styles of lawyering, okay? We hopefully all know the basic tools of defense: direct examination, cross-examination, understanding of the rules of evidence. You have to have the baseline, you have to have the base knowledge. How you execute those is what's what's in question now.
Right.
The his style is bombastic. That's his personality. That just does not him. That in court, that's him. Okay, I know him, right? And you have to. But the question I like to say is, where does that play? Now, remember, he's on the Isle of Manhattan. There's a lot of bombastic personalities there. Okay,
Right.
Donald Trump, the perfect example. Okay, Donald Trump is not going to be a good developer in Hoboken. He'd say, get him out of here. Okay, he's too loud. We don't want to deal with him. I don't think Joe Tacopino would work well in a Hudson County courthouse, although there are lawyers who have that particular style, because he would be seen as, I think, almost a caricature in our region. Okay, just as let's translate this. Brian Neary, with his Jersey City, Hudson County, Hoboken-esque accent, goes down to Camden to do a case. Well, they're Phillies fans, we're Yankee fans. They're Eagle fans, we're Giant fans. Okay, Met fans. All right. So, but either way, we ain't Philly fans. That's even actually the Philly fans. That's even worse.
Even worse, yeah.
That's even worse. Or the Eagles.
So you have to regionalize. Now, the answer to your question, you know what? When the complainant of a sexual assault gets on the stand, the theory has to be that you have to undermine their credibility. Okay. Again, what legal tools do you use? The how to do it is very important. I actually think what Tacopino is doing, okay, is not trying to undermine her credibility that it happened. I think he's trying to undermine her credibility on how much damage it has done to her in terms of money damages. I think that's what he's really doing. Okay. So, and I'm throwing out numbers. Okay. So instead of the case being worth $100, it's worth $10, that kind of stuff.
Right.
Because I think it's basically conceded, without saying it, that something happened in the dressing room. Okay. But she's not my type, and that kind of, that kind of nonsense, that as abhorrent and as misogynist as that is, that's in a court of law. What they're doing is they're measuring how much is it going to cost me. Okay. And I think that, that if there was an insurance, they would have a figure on the file. Okay. So he goes to try to think about this. He goes to trial. Let's assume he loses the trial. Okay. There's going to be appeal issues. They'll jerk the appeal around for a while. So, that's kind of sort of as it goes. Let me just answer that grand jury question about something, about the Georgia thing. Grand juries are not constitutionally required. Okay. Each state can create its own grand jury. Federal government has a grand jury. Not every state, so long as there's a probable cause finding before somebody is held for a crime. But if you have a grand jury system, that it's defined by the state. Now, we have grand juries, but Eddie, remember the thing called a presentation? You could present presentment. Right.
Yeah.
You could present information to a New Jersey grand jury, but rather than indict, they'll say, well, listen, we heard the testimony and we're going to have a written document that says this is wrong. I'll just give a very generic example. Politics, campaign, use of campaign funds, Jersey City election. They choose. Now, I think, Eddie, I'm trying to remember if it was your office, but rather than indict the individuals, they said, listen, this campaign was doing this and buying T-shirts or whatever the hell they were doing with the money. All right, don't do it. What it's supposed to do is give a like this to that particular organization, but at the same time sending a message, hey, everybody else should be on notice that the next time this happens, maybe we're not so nice to give you the finger like this. We're going to indict you. I guess that the Georgia system may have a similar circumstance that allows the fact finding and then make a recommendation that another sitting grand jury make the determination if there are indictable offenses that can be elected. By the way,
Makes
I
sense.
know Trump's lawyer in Georgia. His name is Drew Finley. He's the real deal Holyfield. He is a really, really good lawyer. Tuned into the community down there, skilled guy. I know him from a couple of national organizations. Big rap lawyer, by the way. If you look him up, he's represents lots of, because Atlanta has a huge rap hip hop community. But Drew's the real deal. That's a they wonder how Trump chooses lawyers. Well, that's not because he saw him talking nice on television. He's the real deal.
Well, he used to have another lawyer named Ty Cobb, but it's not the one who's popular in Georgia from 100 years ago in baseball. So that wouldn't have worked. But
Did Ty Cobb represent him?
he was when he was a president. Yeah.
Okay.
I think
He was one of his White House
he was
lawyers.
the legal counsel to the White House.
Okay.
But I want to come back to the question about Trump's statements outside of court that potentially cause problems. I mean, he's not an ideal client, I would say, probably as a defense attorney, but things like any mentions of the judge's family and things like that, we didn't really wrap up that discussion. What powers does a judge or anybody else have to kind of rein him in terms of things that he's saying that could be problematic?
I'd say this to Eddie. So Eddie, you're sitting as the Hudson County prosecutor, okay? And a notorious defendant, I don't know, sends the word that I'm going to send out Judge so-and-so's daughter's picture. My instinct is, Eddie, that you would have Hudson prosecutor's office's detectives at his door, at this person's door, and may very well charge them with some sort of obstruction or some kind of threat to them. This is different, though. This is
Yeah, you're right, Brian. It's different, and you know, I don't know if there's a good answer to Joe's question. I guess the judge, he instructed Tacopina to tell his client not to engage in that type of behavior. Apparently that was done because there was not a reoccurrence of the behavior.
Yeah.
Now,
Joe was talking.
what I want,
Craig case or the Manhattan District Attorney's case.
Yeah, that's what he's
No,
discussing.
but he's talking about the civil case. Tacopina basically was told to muzzle him for the
But also they were apparently, both sides more or less were reprimanded to kind of lower the volume, lower the temperature, is my understanding of what happened at the indictment of Donald Trump.
See, what would deter Tacopina from doing this, or any lawyer, is that while Trump or that client is in usually has one time that they're there, the lawyer, Joe Tacopina or whoever, hopes to have a continuing career in that same courthouse.
Right.
You don't want to tarnish your reputation in terms of your future representation of representing clients, so that there's also rules of professional conduct that define the lawyer as opposed to the litigant.
right.
But I would think that a lawyer, whether it's Joe Tacopina or whatever, would be careful that the client A doesn't hurt the case itself, or B doesn't hurt the lawyer's reputation of his inability to control his client. Eddie, how bad is this a remedy? The guy acts up like that. Would I have a right to go into court and say, Judge, I'm out of this mess. I want to be relieved as counsel because there's a lack of communication between me and my client. I said to my client, don't do that stuff. Okay. He says, I'm going to do it anyway. I don't know. That's just thinking out loud. It's not easy to separate yourself, say, Judge, I don't want to represent the guy anymore, particularly if you're in the middle of the litigation.
Right. That's a difficult proposition, as you know, for a lawyer to get out of the case at that point.
Yeah.
And an attorney, a defense attorney can ask to be relieved, as you know, but that does not necessarily mean that request is granted by the court. But, to just follow up on what Joe is saying or asking, let's assume that Donald Trump did not stop after he was instructed to do so by his attorney. What would the next step be? Would the judge at that point require Donald Trump to appear before him to be instructed that if he did not cease and desist the conduct, he could be held in contempt?
Take Trump
That's-
out of the equation, Eddie.
That happened to.
Anybody? All
Joe
right, you're right.
Client.
Let's
Let's
take,
say Joe Client. I think that that's the remedy.
you're right. All right, let's take, you're right. But that, and I think that is, I'm glad that we have the same mindset on that, Brian, because that's what I think would be the next step.
See, here's the complication of a Trump, okay? Is there a First Amendment? Is there a First Amendment position for a Trump on this? Or is there a, remember, he's a candidate. He's a candidate. So can you suppress the conduct and comment of a candidate, even though the candidate is involved in, I'll use the term, private litigation? Is there a First Amendment implication, you know, right to, whatever it was, right to vote, or whatever the hell it is, okay? And that would impact a litigant slash politician slash candidate slash public official from being involved in that. That's everything we talk about with Trump is not only complicated because of his personality, his inability or unwillingness to follow rules, but his status as former president. He's got an army. He's got his own army around him. That's why he's got his own army. Can't Trump a candidate because he is an announced candidate for president of the United States? Hey, don't suppress my ability to influence my voters, people who may vote for me. My response is this, you know, E. Jean Carroll says you're a rapist and you're a slanderer. No, I'm not. I'm running for office and whatever I'm going to do. It's not. That's why this is so complex, is that not only the complexity of the personality, but the complexity of his position in this society.
Well, you know, Brian, before you joined us, we were discussing the prosecution of Donald Trump for the January 6th riot, or whatever term we're going to use about that. And we brought up the fact that there were First Amendment implications there concerning what he said on that day. And I think that's a viable issue in these cases. Although I don't know if the First Amendment would apply to Trump disobeying an instruction from the court concerning what he was saying. But you're right; these are complex. These are complex cases. And we had said that earlier, that they're not as straightforward as many people think they may be.
Well,
I just want to make it clear though, because I've seen on social media and elsewhere, Trump supporters especially saying that speech is unlimited in this country. And I don't believe that's necessarily true, right? There are limits on free speech, are there not?
Absolutely,
Legal limits.
absolutely.
Yeah, you don't yell fire in a crowded theater. You know,
Right.
Yeah.
So I know there's a standard that it has to be, I forget the exact wording that Supreme Court has used in the past, but imminent and likely or something specific in order
Yeah.
to have threatening language be illegal and cross that boundary. But
Clear and
there are limits.
present danger.
Clear and present danger, yeah.
you know, gentlemen, you might have heard in the background, we're coming to the end of the day at Hudson Catholic, and both Joe and I have some responsibilities after school.
The days never ended Hudson Catholic, Billy.
No.
Never end.
But we,
Our listeners know well that we record this during our little free time here. so.
it's been tremendously enlightening in terms of hearing from people from the legal profession when the sum total of my legal knowledge comes from watching 20 years of Law and Order, you know, so that's why I got my. law degree. But we can't thank the Honorable Ed DeFazio.
Thank you both so much.
Sorry I was late, but the short time I was with you, I had a great time.
And we'd
Thank
like to
you.
do this again.
see ya.
We only scratched the surface, so.
All
Thank-
right,
thank-
Eddie, good to see you, Eddie. Take care of yourself.
Maybe we'll all do it again.
Yes,
Yeah.
absolutely.
I hope so.
Guys.
Thank
All
you
right.
both very
Yeah.
much.
All right.
See ya.
Goodbye.
Have a great
Thank
rest of
you.
your day.
Guys.
Ciao, Ed.
Well, that was great, Bill.
Yeah, it was. The two really, really good guests. I mean, you have a former judge, you have one of the preeminent defense attorneys in New Jersey, and actually who has probably done combat with Ed DeFazio when Eddie was the Hudson County prosecutor for many years.
And interesting that Brian knows Joe Tecopino.
Yes,
Um,
yep.
you know,
So,
explaining his persona a little bit. That is just who he is as a person, but that is his style of a lawyer. But I mean, I know Joe Tecopino is only representing Donald Trump here in this area of the country where that style could work.
right,
But can you imagine him out in the heartland?
no.
No. So
no,
I mean,
things are a little more.
he was saying
sensible.
not even in Hoboken would
Yeah.
this work, let alone in.
You know, I think we scratched the surface on this, and obviously this saga is continuing, and as it unfolds, I think we need to get the two gentlemen back again.
I think
to
we will,
revisit it,
because
you know, but it's been a great afternoon.
it has, that
good-
was
good-
good
enlightening.
conversation. They really cleared up
Yeah.
some of the confusion I had about a few things, about the grand jury system, about immunity. I didn't understand the two different kinds of immunity that can be offered. So that was very helpful for me in understanding that. Those were two great guests. So thank you for arranging that. Those were Bill's guests that he organized for us. As always, listeners, we hope you've gotten something out of this episode. You know, we are educators. We are hoping to educate as well as share our opinions and insights into things. We want to hear from you. We may have our guests on again at some point soon. So maybe even send your questions that you have for them or for us. We can be reached as always at Wigs for Wigs. That is WIGSFORWHIGS @gmail.com. If you don't know one of us personally, we are always available as a group at wigsforwigs @gmail.com. So let us know what you think. Keep up with the news out there, and we'll see you again soon for another episode of Wigs for Wigs. Take care, everybody.